when Tanya gets here, she can just take that.
Absolutely.
I realize.
Oh, good morning. This is May 2nd, 2024. Slowly approaching Cinco de Mayo, which everybody's excited about, I'm sure. So we have a draft 15-page strike-all amendment. Do you want to briefly go through it, Ben?
Sure. So for the record, and good morning, everybody. For the record, Ben Novogroski from the Office of Legislative Counsel. So essentially what this amendment does is in section 1, on the top of page 5, you'll see on line 1 the change, excuse me, from not to exceed a 14-day supply of prescription medication to now not to exceed a 28-day supply, based on the discussions of the committee yesterday. And then scrolling farther down, you'll see the elimination of what was old section 3, which was the expansion of the earned time program to parolees. That section has been struck, and that has now been rolled into what was former section 4, now section 3, into the study of the Joint Legislative Justice Oversight Committee and this is at the top of page 9, for earned time expansion, parolees, and educational credits. So now the Justice Oversight Committee must review whether the department's current earned time program should be expanded to include parolees, as well as permitting earned time for educational credits for both offenders and parolees. Additionally, the review of the program shall also include an examination of the current operation and effectiveness of the department's victim notification system and whether it has the capabilities to handle an expansion of the program. And then the committee shall, in studying that aspect, the committee shall solicit testimony from the department, the Center for Crime Victim Services, victims and survivors of crimes, including those who serve on the advisory council for the Center of Crime Victim Services, and the departments of states attorneys and sheriffs. And then this any recommendations must be submitted to the Senate, to this committee, and to the House Committee on Corrections on or before November 15th of this year. So any questions on that study?
No.
And then moving forward, new section 4 is remains unchanged as far as the non-driver identification cards, and outside of the numbering, section 5 is now the Family Visitation Study Committee, and that remains unchanged. Section 6 is the addition of
can I just ask Isaac if the department's okay with section 5, because we never discussed that yesterday.
Yes, we're all on board for that.
Okay. Thanks, Ben.
Sure. And then section 6 is the
Isaac, you probably should have identified yourself for the record.
Isaac Gino, policy director for the department.
Thank you, Isaac. Okay, now we can go to section 6.
Sure.
Sorry, Ben, for being a little overly prescriptive, but I did want to get on the record with this. You know, I'd hate to approve something and have the department say, oh,
and then section 6 is the establishment of the new report to essentially address the inmate population reduction. You'll see a finding section. In Senator Sears, I could not find the data, like the actual documents supporting the data, so I just went from what was in testimony yesterday, that the General Assembly finds that the population of inmates in Vermont has risen from approximately 300 a day in 2020 to approximately 500 a day in 2024, and that can be adjusted if there are some differing numbers. And then the report itself is due, I made it due for November 15th of next year, because it seemed like sort of a heavy lift, but that clearly can change at the prerogative of the committee. And so it would be led by the judiciary in consultation with DOC, the Department of Building and General Services, DSAS, the Defender General's Office, and the Law Enforcement Advisory Board to submit a report to House Corrections in this committee on methods to reduce the number of offenders and detainees in Vermont correctional facilities. The report shall include identifying new laws or amendments to current laws to help reduce the number of individuals who enter the criminal justice system, methods to divert individuals away from the criminal justice system once involved, initiatives to keep individuals involved in the criminal justice system out of Vermont's correctional facilities, and an analysis of the financial savings attributed to implementing subdivisions 1 through 3 and how any savings can be reinvested.
And it occurs to me that it's my fault, I left it out, but giving the Department of Corrections the ability to contract with an outside company, I'm thinking of the Justice Center. If the Department of Corrections or the state or the legislature wanted to contract with the Justice Center for help with this project, giving them the ability to do that.
Okay.
Or I don't know of any other outside group that they would want to contract with, but giving them the ability to seek outside counsel.
Okay, the department, because technically this is led by the judiciary, but I could basically just say that.
Well, the judiciary, I mean, the group could use the consultation of an outside group. Senator Boss.
Thank you. I appreciate the focus here on policy change to decrease the population. I'd like to keep the intent.
Can I get this one done first, and then?
Okay.
Because you're going to a different subject?
Nope.
No?
Nope.
Oh, okay, go ahead.
The study, I'd like to keep the intent language because the intent of reducing the population is to end the use of out-of-state prisons.
Well,
yeah, I can input, so the intent language from the prior version, just to carry that through.
Yes. Because we are changing this study, and I appreciate that we're focusing on decreasing the population, but I do want to keep the intent that the reason we're doing that is to end the use of out-of-state prisons.
Well, I would argue that the reason we're doing it is because it's not healthy to have people that don't belong in prison.
Well, I agree with you. I agree with you.
However, I'm getting back to my language. Who would contract with CSG? The judiciary or corrections? I thought it'd be corrections. If that was who they chose.
Who else could support the study?
No, I mean, I think it's pretty clear that it would be something like a Justice Reinvestment 3 would be helpful, and now that the Commissioner of Corrections is on the Justice Center board, it might be easier to.
Yeah, we could identify CSG. It could be the Crime Research Group as well, might be a basis of support. I think
they're just giving figures, whereas the Justice Center gives you options and things that have been done in other states to reduce that population. Isaac?
Thank you, Senator. I'll leave the language to Ben, but we also work with the VRA Institute, for example, the Brennan Center, the Marshall Project. We've had discussions with those national.
Yeah, so I would leave it open to any group but whoever, I'm just not clear to me who they contract with. Who's in charge? Is it the judiciary or DOC?
We have right now it's the judiciary in consultation with DOC, and that can be.
Yeah.
Just one more note for Ledge Council. Ben, I think on line 10, you say the population of inmates. I think we might have meant detainees on page 13, line 10. And
Uh,
well,
and
okay, usually in the department, we try to use person-centered language. I know we're trying to create congruency with the rest of statute, but usually using incarcerated individuals when we're talking about all folks.
right,
Yeah,
and I'm happy to change that. I was going from the definitions in Title 28. Inmates is inclusive of both, of anybody that's in the system. Offenders is more specific to those who have been convicted, but I'm happy to further specify, inmates and detainees or just detainees.
But as
If you were to say in your findings piece, besides adding what Senator Bowski wanted, if you were to say that the finding is that, let me go back to it.
Senator Sears, I could share my screen
I would
too,
be
if that would
fine
be
with
helpful.
adding I would be fine with making it everyone, but the finding should be that the General Assembly finds that the population of inmates in Vermont has risen from approximately 300 of detainees, has risen from approximately 300 per day to 2,000 in 2020 to approximately 500 per day in 2024, while the sentenced population has remained fairly stable over that period. And then you get into Senator Bowski's statement about intent to reduce to eliminate out of state, which is,
And that new addition, Senator Sears, while the remaining, do you say population has remained relatively the same?
the
Or
sentenced population has remained relatively stable
Mhm.
over that same period. We haven't seen an increase in the number of sentenced people. What we have seen is the 200 plus increase in the number of detained people, which is what is keeping people out of state. That's the connection to me. And I'm fine with looking at ways to reduce the sentence population anytime we can. But I think I want this to focus on the detention population, because that's where the increase is. But if in the process you get rid of a few sentenced people, that's fine with me if they don't need to be there.
I'm happy to make that change, so I'll go ahead and do that.
Okay, and then, so everybody okay with the rest of this study piece? The way it's moving?
And then
And do
I'll
you-
just add language to giving the option to contract for support with
Yeah.
some nonprofit or I'll figure out the wording.
Yeah, I mean, whatever wording we've used in the past, we've never identified the agency. We don't do that in the budget. I just want to make sure they have the ability to contract with somebody.
Okay.
So now we're to section 7. This is exciting.
So section 7 is entitled Reentry Services, New Correctional Facilities Programming Recommendations. This lists that on or before November 15th, DOC, in consultation with BGS, shall submit recommendations to the Senate, to this committee and the House Committee on Corrections, detailing an examination of the department's reentry and transitional services with the objective to transition and implement modern strategies and facilities to assist individuals involved with the criminal justice system to obtain housing, vocational and job opportunities, and other services to successfully reintegrate into society. The recommended size of a new women's correctional facility, including the scope and quality of programming and services housed in the facility, and any therapeutic, educational, and other specialty design features necessary to support the programming and services offered, and whether it is advisable to construct a new men's correctional facility on the same campus as the women's facility or at another location.
Okay,
And then section 8 is the addition of those positions that
the one problem there is it wasn't intended to be new positions.
Okay.
It's current vacant positions. I believe that was the proposal. Steve Howard, is that the proposal for the state employees association?
Thank you, Mr. Chairman. Our position was vacant positions, vacant classified managers positions.
Vacant classified manager.
And I think it was.
It's not hospital coverage position.
So it's to convert 7 vacant classified managers in state government to these hospital positions.
And would the correct term be hospital coverage managers, officers? What's the title there?
Central Operations Specialists.
It's what?
Central Operations Specialists.
Central Operations Specialist.
Rolls off the tongue. Would these, sorry, just for clarification, would these be positions within the Department of Corrections or department or manager positions across state government?
Our hope is it would be across state government.
Okay.
Across state government. Do you have to put that in?
I'd have to look into that because normally we try to specify which department, because that would be the department that would fund those positions.
Well, but there may be vacant positions in somewhere else that could be transferred over.
Okay.
It only affects the vacancy savings of the department, which loses the position. I mean, they don't lose a position, it's already a position. Yeah, I know that from being on approach, that is, what the governor usually does is finds a number for vacancy savings. And then that is a number, but you can, we're not creating new classified positions.
Okay.
Bob?
Just give me I would just ask for an opportunity to just look into that a little bit, just to get the wording right as far as, you know, these vacant statewide positions, not to pigeonhole them to, you know, unnecessarily.
Yes, I believe the commissioner's statement was it was an agreement with this, and it was his understanding it was through the DOC, not throughout the state of Vermont. And his position was, well, yeah, we're willing to work toward this, but there's 11 down, and you know, so we're willing to increase a couple more, looking at within their vacancy savings within DOC. I'm a little concerned when they say across state government. What does that mean?
Well, it means that you're taking the positions, could be a position from the Department of Children and Families that's vacant. Could be a position from transportation that's vacant, I suppose.
I would just want to know what those positions are.
Yeah, my only my question for that, or I guess concern would be, and you know, potentially Director Howard might be able to answer this, is if there are different like union considerations department to department, and if there would be potential unintended consequences if you're bringing people from one agency to DOC that might have different mandates under their contracts.
Steve, am I correct that state police is the only other bargaining agent separate?
Yes.
So you wouldn't bring a vacant trooper position?
No, and classified managers are not in the bargaining. They're classified, but they're exempt. They're not quite exempt, but they're not in the bargaining.
So these 7 would be in the bargain unit then?
If they were converted to COS positions, they would be. I think the commissioner's concern was if you limit it just to the department, you're actually taking vacant CO positions, which we would be concerned about. I think that's what he said.
Yeah, right.
So we're talking about 7 positions using vacancy savings out of, Steve, how many vacant positions do we have in state government? Or vacant manager positions? What percentage?
Well, there's a total of almost 1,100 vacant positions. I don't know on top of my head how many of those are classified managers.
Okay. To me, 7 positions in the grand scheme of the vacancy savings seems de minimis.
The intent of this committee is the language would reflect the ability to take 7 vacant positions throughout state government and create the positions that were described by Isaac, which I still have a hard time wrapping around, but it's for hospital coverage, is their duty. And I wanted language that would say that the department can still, if there's an emergency, use other staff to cover the hospital. I don't want, is that unwritten? I mean, if you had a outbreak of measles at a correctional facility, and you had to hospitalize 20 inmates, you couldn't do it with that number of people.
No, the current practice under is that, first it's the COS team, these
Okay.
hospital specialists, and then it goes to a volunteer, what we use in Everbridge is the name of the company, a notification process. So anyone who wants to fill a volunteer shift is able to do that if, for example, they want to make extra income. And then from there, if we don't have enough volunteers to fill the spots, then it would go to.
But so you would still have that ability in case.
Yeah, or to bring folks from the facility as well. They're, folks from the facility are oftentimes bringing folks, directly from a correctional facility to the hospital.
I believe it's in the contract.
Oh, okay.
It's standby.
So we don't need anything on that. So the language we're just talking about is acceptable to both?
Yeah, so the way that I've drafted it currently is that to the extent funds are available, 7 permanent classified manager positions that are currently vacant be made available in fiscal year 2025 as operations specialists, as central operations specialists within the Department of Corrections.
Ed, good?
I thought you said 7 vacancy positions, not classified manager positions throughout the state.
7 classified.
Positions, not managerial positions.
Yeah, what is this managerial?
The reason for that is just that the pay grades are comparable. The COS position is a pay grade 24, and classified managers are generally pay grade 24 or higher. That's why we chose that.
I'm just sharing my screen so everybody can see the
I'm
language.
glad you understand all this stuff, because we're not.
I mean, saying that I understand it might be a stretch, but I'm trying to distill what everybody is saying. So, yeah, this is the language here.
Can you read that? I'm having a hard time.
Sure. To the extent funds are available, 7 permanent classified manager positions, that are currently vacant shall be made available in fiscal year 2025 as central operations specialist positions within the Department of Corrections. In addition to any other duties deemed appropriate by the department, the hospital, I'll change the term here, the central operations specialists shall assist in the department's obligations to attend to individuals in custody that are located or admitted at hospitals within the state.
Or use Dartmouth.
Yep.
So I think you have to add,
Albany as well. Okay, we've gone as far as Connecticut recently to find.
I'll just say
I think
located
it
or
could be
admitted
out
at
of state.
hospitals.
Yeah, it could be out of state.
Yeah.
I suppose from Rutland, it might be closer to Albany than Dartmouth. I mean, than Dartmouth or Burlington.
So I just cut off within the state and it's just left it as located or admitted at hospitals.
Yeah, that's good, yeah. I don't think that presents a problem. Senator,
I don't know if this is,
yeah, senators. I'm sorry.
I don't know if this is getting into semantics here, but instead of be made available, would it be more clear if it's be converted to central operations specialist positions, or would that really not make a difference?
I think it really depends on what the goal is, to make them available or to actually make them into those positions.
From what I understood from the conversation, it seemed like we were taking those 7 positions and converting them to central operations specialists. Is that, am I misunderstanding?
That was my understanding.
So does that mean these positions are gone then? After this converted to the 7 other positions, does that mean these managerial positions are gone then?
Well, they're no longer available for some other purpose.
So they can't be filled if they wanted to fill them, is my question.
They won't exist.
I mean,
won't
I
exist.
believe they do this all the time in state government. And if you, one of the complaints from the Senate Appropriations Committee to the House Appropriations Committee was that the governor used, say, 40 million or 60 million in vacancies to balance his budget, and then the House took another 5 million in unspecified vacancies to balance their budget.
Yeah, I think the thing that I wanted to just make sure is clear is that, you know, we're not creating 7 new positions
Right.
and then leaving these other 7 positions vacant, but rather we're just taking those 7 positions and converting them that way.
Shifting them to DOC for the purpose of the hospital coverage.
Yeah, and this language would achieve that now. They're not new positions, just 7 permanent classified manager positions that are currently vacant shall be converted to central operations specialist positions within DOC in fiscal year 2025.
I think it would be helpful if you dropped the word appropriation in the title.
Probably would give people a little less heartburn, so.
Yes. Yes.
Just one question, who is doing that then? Like, who's the agency to convert these positions? Would that be like AOA? Who's instructed to do that? Because I just don't think it's within the jurisdiction of the commissioner to convert positions.
I think it's human resources.
Oh, GHR? Right. Just to be clear on that.
Well, we do this all the time in state government. It's not unusual to take vacant positions, but that's.
Yeah, and Senator Sears, just with that in mind, I'll leave this language for now, but since this is something that is new for me,
Yeah.
I just would like to double check with my colleagues to make sure that I'm not reinventing the wheel here.
Well, why don't we double check the language and then have a vote tomorrow morning when you're scheduled here.
Okay.
You're scheduled at 10:45.
That sounds good to me.
Plan on a complete redraft and a vote at 10:45 tomorrow morning.
Okay.
Is there any further discussion of what we have? I mean, I'd like to vote it out tomorrow unless there's some changes that Ben feels he needs to make because of our discussions. So,
Yeah, I know that this is based on the last draft. It's the not to exceed a 28-day supply is exactly what I asked for, but I'm wondering why it's not to exceed rather than a minimum of. Ben, do you recall the House discussion around?
There are a couple things at play here. So the WellPath contract right now, the way it's structured is that they give prescriptions of, I believe, 30 days. So it would require a contract change if we were to exceed that. There was also, I would say, substantial discussion though of, I think yesterday maybe it was a bad example where I was using sort of ibuprofen, but this could also be controlled substances, Adderall, and medication that has a greater danger of misuse, appropriation, or abuse. And so while the 14 days was relatively arbitrary in one sense, the discussion that the House Corrections and Institutions Committee had was that was enough to basically give that bridge amount with, minimizing the risk of abuse, misappropriation, and then that combined with actually having a prescription in hand to redeem would balance that out. So that's a long way to answer the question. 30 days is the limit within the contract with WellPath, and then 14 or 28 here is sort of the policy decision to balance those factors.
Okay, yeah, no, I guess my question is less about the 28 days. I recognize that I asked for that, and more about the language of not to exceed versus a minimum of. Like, I really want to make sure people are going out with a month's supply of medication.
Yeah,
Not, you could give them a month's supply, but also you could give them less.
so I think that would require, I mean, you could do that, absolutely. Where it would a minimum of, but again, WellPath would only supplies up to 30 days. So then the prescription, at least based on the contract that they would have in hand, in addition to the actual supply, would probably only be for an additional 2 days.
Okay.
So, I mean, that's a policy decision.
Yeah,
But I'm just explaining the sort of the constraints that
so
we're
hard
considering.
to work with the rules of a private provider like WellPath, as well as the rules of Medicaid and the rules of other drugs. I mean, I remember a time I went to Florida and just refilled the prescription that I really needed and left it in Bennington. Went to the CVS in Florida and they said, certainly we can refill this for you, but it'll cost you $800 because you don't have a copay because you just filled it. So,
Yeah.
ended up getting some kind of deal that cost me $300, but you know, it's that type of stuff that goes on that is beyond my ability to deal with, and
Yeah.
appears to be beyond the.
I mean, I'd like to
I
see
mean,
us.
I agree with you on everything about that. I think most common sense, you lead with as much as you can. I mean, but you know, it's situations like that that just really drive me crazy.
Oh, absolutely. I mean, for-profit healthcare is a problem.
So anyway, anybody else who has a comment on this, Isaac or
I have a question that is related, sort of,
for Ben?
for Isaac. And that is if there is any movement or consideration to actually bring healthcare back under the arms of the state rather than contracting with a private company, because it seems to me that would solve this problem.
Yeah, we actually addressed that during joint justice last year.
Yes.
And we were instructed to put together some cost estimates around what it would take for the state, AHS and partners to
It was
provide that care.
estimated to cost, I believe, 60 million more than the contract.
Yeah, it's about 100 million annually, we think.
Yeah, but the contract is.
And the contract is about, 35.
So I'm in the ballpark.
Mhm. So I think, that's a conversation legislators would like to have, I think the department for its part is agnostic.
Part of the problem is, in my view, I'm not gonna speak for the department or anybody but myself. Part of the problem is we're limited in the companies that contract to provide healthcare in our prisons. And that limitation has had disastrous effects, not just in Vermont, but around the nation. I know that Senator Elizabeth Warren and Markey in Massachusetts have been going after WellPath down there for their poor care of inmates in Massachusetts. And I believe there are other states with the same concerns. And Congress is actually, I believe, God, waiting for Congress to act could be like waiting for Methuselah to live here. But Congress, as I understand it, has actually been looking at this situation and the health care inside prisons.
We're certainly, to speak for the department, we're very interested in new models, innovative ways of providing, high quality healthcare for incarcerated folks. I think one of the big difficulties we struggle with is, as we talked about yesterday, the Social Security Act of 1965, which prohibits Medicaid coverage for incarcerated folks. And that's been that way since 1965. That makes it very difficult to create parity with community healthcare when that underlying funding mechanism isn't in place. But certainly, we're happy to have further conversations about what the state-sponsored system might look like, or an interstate compact, with New Hampshire and Maine, for example, something we talked about a little bit. But it's a complex issue, and I think also the economy of scale is difficult in Vermont. Being able to recruit providers would be difficult. The University of Vermont has difficulty recruiting technicians and nurses and doctors. I think that would continue to be an issue.
There was a time you had private contracts I know with dentists, because my dentist moved over to the Hanover area, became the dentist. This is years ago. You're retired now. But, I know you had contracts at one time with private talks, so whatever. Anybody else with any comments? Senator.
Not quite.
Senator.
Thank you, for the record, Paul Cushilling, Advocacy Director at the ACLU Vermont. I just had two quick comments on this, but I appreciate a lot of the work that's been done in the direction of the studies. We would say we are disappointed to see that the earn time section is no longer going into effect and is moving to a study. I understand that is where the committee seems to be going in that, but I'll note that. In terms of the inmate population report, understand that might be a heavy lift with the date now set as November 15th, 2025. But if the committee feels like that much time is needed, I was wondering if there might be the possibility of asking for an interim report for in January, for when the legislature convenes, to see if the work that has happened to this point has identified any actionable strategies. Not saying that they have to have the full report ready by then, but if that working group has come up with recommendations that they think could be helpful to inform the next legislature.
I don't have an objection to having an interim report.
Yeah, just thought that might be helpful, especially.
Yeah, if there are things that we could do right away, why wait?
Yeah.
Ben, can you add that?
Yeah, so would, say January 15th of 25 be a good sort of check-in date?
Yeah, or actually December of 2024 with the Joint Legislative Oversight Committee at their December meeting. And you could put the interim report due on December 1st, and then if we're not meeting till the 15th or whatever, we're covered. But we always have a December meeting.
I'm just to let you know, Senator Sears, Justice Oversight's getting pretty packed this summer now, so just.
We'll take care of it.
Okay.
We'll zip through it. We'll actually, unlike other committees, we'll actually meet 6 hours a day rather than 2.
So I will add December 1st.
I understand it's getting full. Our first meeting will be in June. If we need an extra meeting, we can always ask.
So December 1st check-in, do you want me to write in language that they will testify before the committee in December as well?
No, just file a report. Obviously, they would probably come in, but just to have a report available on December 1st, 2024. That way, if there's legislation, we can have it.
Would you like it to be a written report, or just it could be an oral report?
I like writing.
Okay.
I don't think it's interim, so make clear it's a outline. Put the word outline in.
Okay.
And any suggested legislative changes.
Okay. I can do that. And then where did we land with the 28 days? Did the committee want to set a minimum of a 28-day supply? If so, I think that there would be some more changes needed.
I think the word minimum of 28-day supply, if possible.
Okay.
Because it covers, if there's a situation where, for whatever reason, they can't get a 28-day supply.
Right, because right now in this provision, it
And if
outlines
it's a
that.
little beyond that, but I would hate to see the Department of Corrections not doing what they're supposed to do if they can't do it because of federal or other rules.
Right.
So if possible.
Yeah, and just so you know, it's currently qualified that the medication has to be available and it has to be clinically appropriate as the provider. So that's why I'm suggesting it might need to change a little bit. If the legislature is mandating a minimum supply, you might want to remove that clinically appropriate language, because essentially you're mandating that, and maybe a clinician has a different
I think-
opinion.
I think if you use the word if possible, you do the 28 days if possible. Or your idea is what? I think we're getting,
Well, right now it's based off of availability and clinical appropriateness. I think that language would need to change though, if you're mandating a minimum number.
you can't mandate what they can't deliver though.
Yeah, I think if we still leave the clinical appropriateness, and I mean, I suppose we could structure it around, if it's clinically appropriate and the medication is available, they should leave with a minimum of 28 days supply.
Okay,
That, I think, gives that flexibility if for some reason the clinician is like, I don't think it's safe for this person to have 28 days supply of this medication, but mandates that in any instance where that is not the case, they are gonna leave with a 28-day supply.
okay. I'll wordsmith it.
Thank you.
Okay.
And then one final thing, I didn't know if the committee wanted to do a straw poll on the amendment to H 645 prior to breaking, or if it's good as is.
I thought we already did.
I thought you sent out an email that I replied that it was good by me.
It's good by me
Was it
too.
good by Senator Sheem and Norris and Wowski?
Well,
I mean,
I didn't, I'm sorry, Senator Viofsky, I didn't email it to you or Senator Baruth. I only emailed it to the sponsors of the amendment.
Okay.
But I didn't know if the committee as a whole wanted to just,
Yeah, I thought yesterday we straw polled the ideas that were going into the amendment.
yeah,
I
I'm
haven't seen
just
it, so.
crossing T's
But I
and
trust
dotting
you.
I's.
Well, I wrote you at 5:30 this morning.
You did.
Thank you for your 11:30 email, and I thought it was pretty prompt for tomorrow.
Well, I just wanted to make sure I wasn't missing anything. So it's all good. We're all good.
Yeah, good for that.
Okay. And then
Anybody
I'll
else
work on
with-
this and get it ready for tomorrow.
Anybody else with any comments and miscellaneous corrections? I will admit we've avoided the issue of bed size for a number of reasons. It seemed like we would get bogged down forever. So with that, I'm gonna walk out of the room, turn it over to the vice chair and Senator Fitzpatrick for the miscellaneous judiciary bill, which is growing by leaps and bounds.
Thank you, everybody. Have a nice day.
Thank
Thanks,
you.
Ben.
Thanks, Ben.
And Senator Ben? They used to call these Christmas trees, but I think this is gonna have more ornaments.
We've had some really bare Christmas trees this year, so let's fill this one up.
The new amendment is right on top.
3.1. It's
Yes.
So we're just doing a walkthrough of the changes.
Yeah, I think so. That was my understanding. And it is hefty. I've been working on miscellaneous bill for a long time. This is probably the heftiest one that we've seen so far in terms of the amount of other legal issues that are involved, other bills that were their own standalone bills for a while. So this one looks like it's in first place by quite a bit at this point.
Excellent. Well, feel free to take it away.
Yes, will do. Morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to walk the committee through the most recent draft of the annual Judiciary Miscellaneous Bill, which is page 878. There are several changes between this draft, although we started the walkthrough actually of the changes the last time I was here, but because of time constraints, we weren't able to get through. So all of these highlighted provisions in this section aren't necessarily different from the version that we looked at in 2.1. but we hadn't gotten to them yet. So a couple of things are different. Based on testimony that you heard, you may recall hearing from Judge Zone, for example, on the issue of placing cameras on other people's property. He had some suggested language, so you'll see where that is. That's inserted, but otherwise, actually, this and 2.1 are pretty much the same. So having said that, the yellow highlights indicate where the changes are between 3.1 and 2.1, or at least where the changes are that are between 2.1 and 1.1 that we haven't got through yet. So starting on page 9, this actually we had already talked about. You may recall this is a request from the Department of Mental Health. This is subsection F, top of page 9. Has to do with, well, there's two things in there actually. Remember, this is in part the idea that the committee discussed last year and enacted into law to permit trained psychologists to testify on the competency of a defendant in addition to psychiatrists. Remember that sort of big picture issue? So that, you'll see over on page 8, for example, no change, but that's line 10, page 8. That was originally going to be only in effect for 1 year, but now it's in effect permanently going forward because Justice Oversight looked at it and came back and recommended that psychologists should be permitted to offer their opinion on the initial competency proceeding going forward. So that's what's going on. But a couple of sort of related bootstrap issues for that. For example, bottom of page 9, clarifying that the report can be admitted, so it's not just a psychiatrist. If you're going to be having a psychologist be doing these things, then the psychologist report should be admissible too, the same way the psychiatrist is. That's page 8. Same, top of page 9, line 2, you'll see introduction of the report shall not preclude either party or the court from calling a psychiatrist or a psychologist, again, because it could be one or the other of these professionals that's doing the report. And then lastly, the last sentence is to clarify that the psychiatrist or psychologist, as the case may be, who wrote the report can testify at the competency hearing remotely. And that was the issue we talked about last time with respect to the confrontation clause. And does that implicate that at all? I think my answer, which I stand by, I said, yeah, it implicates it. But the case law seems to indicate that the protections in a pretrial proceeding like this one are different with respect to the confrontation clause than they are at trial. And the cases that I found on it specifically said that with respect to these pretrial competency hearings, it's unresolved at this point, whether or not the confrontation clause applies. So someone could certainly litigate it up to the Supreme Court to decide, but I think you have enough of a basis to proceed forward if you choose to.
I wonder, so what I noticed is it's the person who wrote the report shall be permitted to provide testimony. I wonder if that was a may, if that would allow for someone who might be a defendant, but want to have that ability for the person to be in person to actually ask for that and have that. Does what I'm saying, like, I wonder if it helps with the potential constitutional issue to put in here that if the person, or they shall be permitted unless the defendant requests that they be in person. Do you know, I don't feel like I'm very articulate, but.
I have this, I think, the same question. So from what I'm understanding from what you said, these are considered pretrial competency hearings, and the Sixth Amendment does not apply to pretrial.
At least not with the same force.
But if if it's an evidentiary hearing, then would it apply to this?
At trial, if it's at trial.
Okay, so
if the courts have specifically stressed, it's a trial right. So.
Okay, yeah. So I'm thinking to the rule, the criminal procedure rule, if the defendant is contesting the competency hearing, would the psychologist or psychiatrist then be required to testify in person?
It's an interesting question. I think you want to maybe permit, so I see what you're saying. It's maybe if you change shall to may, then you allow the court to do it if it's appropriate under circumstances.
Because, okay, yeah. So I think I was unclear because maybe I'm misunderstanding, but if it's saying notwithstanding any other provision of law or rule.
Right.
And then if, we're looking at the rules of criminal procedure, as best as I can remember, if it's contested, if the defendant is contesting the competency hearing, then I think they would be required to testify in person. Am I close to that? Okay, all right. So does the language as it's written, is it in line with what the rules of criminal procedure control right now?
I think the point is to overrule the rules of criminal procedure. That's the whole idea. Because the decision of Judge Pact that said that the testimony had to be in person relied on both the rules of criminal procedure and the confrontation clause. It wasn't really in detail about the confrontation clause, didn't cite any cases, so it certainly was not a detailed examination of it at all. But the idea here is to say, well, notwithstanding what the rules say, notwithstanding what the result would be under the rules, because otherwise you run into the possibility that, well, you don't want if it's a policy choice for you, but if you wanted to have that policy choice be in place, you don't want to run into the same interpretation of the rules that Judge Pack had in the case, which is that, hey, the rules and also the confrontation clause require in-person testimony. If you, as a policy choice, want to go the other way, then you need to notwithstand the rules.
Okay.
Just to be clear, not to say that some other trial judge might reach a different conclusion, certainly possible, but if you want to be certain, then you want to say notwithstanding the rules. Otherwise, you're subject to the same decision that he reached in that case.
Okay. Thank you.
I don't know that I feel good about that.
Which part?
I certainly understand that there may be instances where it makes perfect sense for someone to attend remotely, but I don't feel good about saying that actually we don't really care about the rules or the Constitution. Like you don't actually have the right, if you're contesting this competency hearing, to have that person in person. I don't feel good about it.
I think the confrontation clause question, it sounds like that question is unresolved, open.
Yes, and you can't overrule it anyway.
Right.
You know, it is what it is. You can't legislatively overrule that. I'm just providing you some background on what I've read in the cases to say that I think you have a basis for doing it if you choose to.
I don't feel good about it.
All right, so
Feel free to
move on though, just to go
Yeah,
put that in the.
we can come back to it.
So the next section, 12, has to do with, I think we did talk about this one as well. This has to do with the Crime Victims Compensation Special Fund and the Sexual Violence Special Fund, which have been undergoing some funding challenges for some time now. And there have been JFO reports as to how possibly to address their funding shortcomings. And the proposal you see on page 10 that subdivision E starts on line 14. Currently, for criminal offenses, traffic violations, that sort of thing, there's special assessments that are imposed that the defendant has to pay, and a percentage of that assessment goes into these funds, right? So this basically increases the percentage a little bit. So you see, for example, line 15 goes from, it says $33.50 of the $47 goes into the Crime Victims Special Fund. Right now it's $29.75. So it's an increase of about $4 per one. So that's what they're trying to do there, is increase the funds that go to those special funds from the assessments that are imposed on a criminal or civil defendant. So that's that piece. I think we go forward quite a bit here. So now we go to, you may recall, the powers of attorney forms that are in. There's two different ones. There's the general power of attorney form and the real estate power of attorney. The real estate power of attorney one starts on page 26. And what this is doing, again, remember the big picture discussion was under the bill that the Uniform Act that you passed last year, the sort of default, if someone wanted to have certain powers included, was that they checked the box if they wanted it included. The practitioners worked with this, decided it made more sense for people who were executing powers of attorneys to strike through instead. So that's what you do in the regular form. But then they realized, well, with respect to this real estate power of attorney form, it actually makes more sense to check the box rather than strike through. So that's what it goes back to. That's what's going on page 26 through 27. You have the humorous typographic correction on page 28. If you remember, inadvertently, it's the paragraph said self-healing. It's actually self-dealing. So that should be fun for the full report. Over on page 30 to 32, those sections are all just moved to a different parental bill that you have in committee. So those got moved to one of Michelle's bills. So they're out of this bill, but they're not completely gone. From there, we go to, let's see, that brings us quite a bit forward to, oh, okay, so page 47, this is actually connected to Judge Zone's testimony on page 55. So we've got two kind of similar sections. Remember, they have to, one of them has to do with placing surveillance devices on private property that belongs to somebody else. That's the new section on page 55. And then you have this existing section in here that was put in by the House that had to do with operating drones over private property without consent. One of the, actually, I don't think this piece was Judge Zone, one of your other witnesses pointed out that there was no exception for law enforcement officers. Remember that? So that gets added in both places. So you see top of page 47. Obviously, they're still subject to the warrant requirement and all that applies otherwise, but otherwise it would have been unlawful for them to operate the drone at all, even if they did have a warrant. So that's added there. So you'll see the same thing added at the end of the bill. That's actually perfect timing, Senator, too, because I was just about to get to the estate tax piece of this bill. Yes, the enhanced life estate deed. Yep. So that starts on the next section, page 47, goes for several pages. Remember, this is the whole idea that when someone does a life estate deed, that the way it's occurring right now, and Senator Sears' experience is that the property transfer tax is imposed at the time the estate is created, instead of later on when the property is actually transferred. So what this language does that you see on page 48 in particular is it bumps that time period out so that the tax is due at the time of the transfer of the property rather than at the time that you execute the deed. In the meantime, a form is filed with the tax department, and the completed property transfer notes the amount of tax due, and that's recorded so that it's going to be known by attorneys who are doing property searches, title searches, for example, when there's a sale of the property, so they'll have notice of that, and then they can then request from the tax department a statement of whether the tax was paid or not. Because if they don't get that statement, then there could be a cloud on title that would prevent transfer of the property, or at least impede it. So that's what's going on, pages all the way up through page 51. This section, I think you heard testimony from the AG about this, although I'm not sure. I wasn't here. This was Michelle's.
This is the issue of the revenge film.
Yes.
Using AI, basically.
Exactly right.
That's what it is.
It is what it is. So right now you have the revenge porn statute, disclosure of sexually explicit images without consent. So if someone takes sexually explicit images of another identifiable person who's nude or engaged in sexual conduct, and then with the intent to harm, harass, intimidate, threaten, or coerce that person, they disclose it to another person without consent. That's what the offense is, and this adds.
I believe that we heard from Michelle, we heard from the Attorney General. We did not hear from the Defender General, and I believe that this is one of the issues that you want.
So that's the gist of it. You already heard about, so you know the substance of it already? Everyone's
Yeah.
familiar with it?
I think, yes, we're familiar with it, it just, we haven't heard from all the witnesses
Right.
on it yet.
Right. So the next section is on page 54. This was a request from DCF. You'll see what it essentially does is it makes, clarifies that non-payment of child support is not a valid reason for terminating parental rights.
That's truly a technical.
Yes, I think that's practice anyway. Right.
What this bill was designed for, I guess.
Yeah, that's right. So the last section, other than the effective date anyway, or the last issue is starts on page 55. This is the one that I was mentioning earlier and that Judge Zone testified about regarding placing surveillance devices on somebody else's private property. So the two changes here are, first of all, clarifying that, there's a law enforcement officer exemption for when a law enforcement officer acts with legitimate law enforcement purposes. That's on page 55. Over on page 56, you'll see this, this is the language that Judge Zone suggested as a redefinition of surveillance device. So I tweaked it a little bit editorially, but for the most part, that's what he suggested. So surveillance device means a device hidden or obscured from plain view that permits the observation of privately owned real property or the activities of a person on the property in a manner which invades a person's reasonable expectation of privacy.
Okay, there are, and I'm sorry, I missed part of the walkthrough, but there are two other issues, I believe. One is S-192, the forensics facility.
Right?
The Agency of Human Services has asked for language, and Stuart Scher will be testifying about that after Rebecca Turner testifies. And then finally, adding the provisions of S-150 as it passed the Senate, that's the auto insurance bill, to this bill, because it appears the House Congress is not interested in taking it up. And I think it deserves, I think we were pretty strongly in support of it as a committee. Those are the two others that I think, but it's only parts of S-192, not the whole thing. The health, the human, what is the name of that committee? Human Services.
There's the healthcare committee and there's the committee on human
Healthcare
services.
committee and health, it's not healthcare, it's human services, struck portions of the bill that I believe the department needs to begin a process of establishing a forensic facility. And that's what they've asked. Anyway, I will let people testify on that. So why don't I, thank you for taking over. On the phone with my doctor. So the next witness, Eric, is there anything else anybody wants to add to this?
I had sent you a couple
Oh, yes, you
things.
did.
The current misalignments of the crack cocaine statutes and setting those the same. And then the personal use, these, and to be clear, these are all things that have previously passed.
Understood.
And then the civil forfeiture reporting were the three things that I had sent you to take a glance at. And if we're too late.
I thought the House passed the bill on civil forfeiture.
The House passed a full bill on civil forfeiture, when I was in the House. This is only one piece of it. It's not any prohibition on civil forfeiture. It is simply the reporting aspect, because right now we have no idea what's happening with civil forfeiture. So it's not the whole House bill. It's just one little piece of it.
I'm gonna say, I don't mind, I have a problem in this bill putting in personal use.
The board that establishes what personal use is?
Yeah.
Okay.
But I don't have a problem with adding the cocaine, crack
Okay.
similarities. We did that in here.
I have some language for you.
I was gonna
Shall
say,
I
draft.
think we did that a few years ago.
We did both a few years ago.
I thought we passed it out of the Senate.
The governor vetoed it.
Governor vetoed?
Yeah, both the personal use board and the crack cocaine statutes were vetoed by the governor.
Were they part of something? I'm just curious.
They were part of the overdose prevention center study.
Okay. Right.
And civil forfeiture is for police agencies.
Yeah, reporting on what's happening with civil forfeiture.
Okay. Can you get those to Eric?
I will send them to him right now.
Thank you.
So no board, yes to the civil forfeiture report and the
Yeah.
crack cocaine alignment. All right.
Well, I think the personal use study is really helpful.
Okay.
It always came out of there.
All right.
So where did the civil forfeiture come from again? I know it was a contested bill that came out of the House Judiciary.
So the whole bill that came out of House Judiciary actually put some prohibition on civil forfeiture and required reporting. This is a bill that's on our wall right now that is only the reporting section. There's no prohibition.
I thought it was sent to the Senate, and the Senate sent it to a study.
No,
Pretty sure.
we didn't want to eliminate civil forfeiture.
Right. And this bill does not do that. It's just the
We
report.
wanted to keep it,
Exactly.
but they wanna know how much is actually.
Yeah, this is just the report aspect.
At a statewide level, little or nothing, I can tell you, so.
Well, I will be happy to see that.
All right, Rebecca, if you could be brief as possible, because we lost an hour of committee time to stupid 4 hours.
I heard, I appreciate the heads up, and I will keep it focused. And I will
This
get,
is a big bill.
it is a good big bill, I think I'll focus mostly on one part to keep it simple.
Yep.
And that's actually, what came up this morning, which is related to the proposed amendments to the scope of competency. And that's regarding the, changing current Vermont law, that shall permit remote testimony of psychologists and psychiatrists.
Yep.
That proposal's on page 9, and that is, I think, I don't have the lines on that draft. But what I wanted to share with you was what this is doing. This is doing a categorical about face to current Vermont law, criminal rule procedure 26.2, that I can speak about the process of how that rule came to being, and to give you some context, some historical context as to what is going on here. We currently have a rule of procedure 26.2 that governs the testimony of video conference in all stages of the criminal case relating to evidentiary proceedings, which a competency pretrial proceeding is. It is, of course, competency is one of the most fundamental points of a criminal trial. All parties, the court's on the same page. We cannot have an incompetent defendant go forward. So of course, that's by definition pretrial, right? If it comes up. We need to make sure that that determination by the judge on competency, when it's been contested, is reliable, right? The determination and the whole due process and fundamental fairness, the society's trust in our system depends on the trust we can put in that determination. And so 26.2 and pretrial competency hearings take evidence in the sense of that word, in the sense of psychiatrists or psychologists providing reports. And so it has come up, there was reference to a decision by Judge Pack recently applying the straightforward rule of 26.2 that doesn't allow for remote testimony to go forward in these competency hearings where the criminal defendant objects to it. It does permit it when the defendant consents. And that's because there are concerns about the constitutional confrontation and due process right. Let me share with you that this criminal rule of procedure 26.2 didn't just happen overnight. I've been a member of the Criminal Rules Committee as the Defender General's designee since I became supervising attorney of the Appellate Division in 2015. Since my tenure on the committee, which has been throughout since 2015, we have been discussing and talking about what to do about remote testimony criminal proceedings. We have discussed proposed changes to the rules, the current rules, and then of course what happened was COVID. And even before COVID, we were ramping up to review because of changing technologies, remote technologies in the courtroom. But then COVID happened and it shut court down, and we had to operate with the court's emergency order AO49 that permitted remote testimony in certain circumstances. And as we exited that period and went into the court backlogs, but with the influx of court technologies, of course, the court adopted a follow-up AO38, Administrative Order 38. These orders incorporated what we learned and experienced in practice, but also the understanding of constitutional concerns of remote technologies and specifically remote testimony taken in a criminal case outside of trial. We're talking about pretrial proceedings as well and post. And Rule 26.2 was born as a result of all of this process, years of pre-COVID, pre-technology, emerging technologies, the experience of COVID, experience of court backlogs, and then post. And 26.2 was just promulgated by the Vermont Supreme Court after extensive process and review last year, July 2023. And of course, during In the normal course of these rules, the committee, I have a pile, I started printing it out and I just decided not to waste more paper to review it. The minutes of the committee from 2018, almost every agenda, we talked about this Rule 26.2 to discuss it. We discussed it, sent it out. We had a subcommittee committed to it. We, of course, when we unanimously approved it out of committee, the committee members included representatives from the Attorney General's office, State's Attorney's office, members of the Judiciary, and the Defender General's office. When this 26.2, the current version, which again does not allow for remote testimony to go forward over the objection of the defendant, it was unanimously approved. It went out for public comment, went out to the bar for comment. And when we received some comments to it, we incorporated and considered it again. And one of the primary concerns was the constitutional due process and confrontation rights that would be implicated if remote testimony were permitted over this objection. And so those concerns you see embedded in the reporter's notes of 26.2 were highlighted. And with all due respect to legislative counsel, there are citations to Vermont law to explain how the committee arrived at the constitutional concern. Of course, again, once a rule is passed out of the committee, it goes up for review by the Vermont Supreme Court, and they adopted it. And then, of course, through the normal process, it went before the Legislative Committee, Rules Committee, which I understand there are members on this committee on that. And that rule 26.2 was presented to that Legislative Committee in November of 2022. There were no concerns raised at that time of 26.2. The State's Attorney's Office was there and voiced some concerns not relating to the confrontation issues or to carve out exceptions for certain type of proceedings, and went forward. And so here I just want to share my great alarm. Personally, as a member of Rules Committee, which have reviewed this issue and the complexity of it, not just with our committee, but overlapping it with sort of the judiciary's overall grappling with how to integrate remote testimony technologies consistent with constitutional rights. They formulated and they had other rules committees of the Supreme Court consider remote technologies. They had a special video committee formulated to consider this. And all of which was to say that to make this suggestion change now without taking testimony from certainly perhaps I would recommend the reporter of Criminal Rules Committee, Judge Walter Morris, who can give that perspective of it. That this is just a huge about face that lawyers and judges have spent time considering and did not work in an exception. And finally, for perhaps legislative counsel, if there's further questions, the U.S. Supreme Court, while reviewing whether or not the confrontation due process was triggered in a case on competency, this is Kentucky v. Stinser, 1987, they absolutely made the point that in certain evidentiary concerns, their pretrial confrontation and due process concerns could apply. And the dissent also spells that out. So again, alarms went out there because of the categorical language, the shall, to every case. Discussions here as to whether or not changing it to may, Senator Bahovsky, when you suggested may, I think would still be confusing because of how legislative counsel said that we would keep the first part of that sentence, notwithstanding other law.
Okay.
If it were switched to say consistent with other provisions of law, of course, this testimony may be done remotely, and that's consistent with Rule 26.2.
I have questions or maybe comments. Number one, that all is true, and my role as a member of the Judicial Rules Committee, I'm sure I approved the rule. But when the legislature began looking at the issue of whether psychologists, doctoral level psychologists should be able to do competency hearings, we learned a lot more in this committee about the lack of ability to get psychologists and psychiatrists. We also learned that in many cases, the psychologist or the examiner would block off time, and then the hearing would be canceled, whatever, and their time is wasted, and we have to pay for that. And then we heard that, the delay creates holding people in jail who may not be appropriate to be in jail while awaiting competency determination. So when this came up and Judge Patch decided to require attendance rather than using remote, I, was immediately contacted by the state's attorneys and some others, and we talked about it, and given all that, that's the reason it's here. I'll take full responsibility for it, but it's based more on recent knowledge of the system that I didn't have at the time that I approved the judicial rules that you were speaking of.
And I can appreciate certainly the concerns you raised are absolutely the realities of every case and going before the court right now. And that's exactly what was considered during the committee and during the getting the comment, these practice realities. Ultimately though, the concern is it hits up against tension with reliability of the testimony, constitutional concerns, right? Fundamental due process concerns. Again, not just about.
I also should have added that I become more convinced that remote is fine. I mean, we've had all kinds of witnesses remotely here this past 2 years. And, it hasn't been due to COVID, it's been due to the availability, number one, and number two is people that avoid coming to Montpelier from Bennington or Brattleboro, let's say, and would have to wait here for us to take them and may run out of time like we do with you sometimes. So there's a convenience that can't be overstated. And I think I understand your concern, but I don't understand what is gained by having the psychiatrist or psychologist in person versus remotely, where they can be questioned, you can see their body reaction, you can see whatever.
Right. And again, I just want to stress that the current law allows for that, allows for those considerations, right? It does allow for remote. The issue is when the defendant doesn't consent to it. And what is gained by the in-person, you talk about, and we know what is actually lost as someone who has shown up on the screen or has tried to do oral argument video. You can't see the facial expressions in the same way as you read in the room. These determinations that judges have to make turn on the most subtle of demeanor and turn on credibility determinations that can come out there. Confrontation, again, is sort of it's distilled, I think, in an inaccurate way of just being a right to face-to-face confrontation just per se. It's again, because of the built-in understandings. What we understand fundamentally with our interactions with people, how much is lost when you talk to someone 2D, when the stakes are so high. Sorry, yes.
Any other questions or comments?
My comment to this is an understanding, doing the work that I do, there are certainly clients of mine that I deem it is clinically inappropriate to meet on Zoom because I can't engage with them because they're high enough needs and I can't engage with them in 2D. So I do support, if we're determining competency, I would probably, as a clinician, make the decision that person needed to be seen in 3 dimensions, not 2 dimensions. So I do hear what Rebecca is saying on what is lost.
You mean the psychologist would have to be? This isn't an issue where who's the only one that's not remote now is the psychologist.
Right. And what I'm saying is from my clinical perspective, when someone is acutely struggling to the point where competency might be in question, I, as a clinician, would make the clinical decision that I wanted to be in the same room as them.
Right.
So I do hear what Rebecca's saying.
Any other comments?
I'm a little conflicted. I see the points, I understand the points that are being raised, but, you know, I also understand the challenges of, you know, the delays that come from, you know, trying to get a psychologist or a psychiatrist to, you know, fly out here to testify in person, and then the hearing gets delayed, and they're just here. And, you know, the lack of mental health professionals who are physically in Vermont who can go in person. But then that's weighed by the person's rights to confront. So that's all to say, I'm conflicted.
Again, the current law is that it allows for it, right? And so we're talking about a narrow situation.
I think we got the point.
Okay,
The problem is the reality of 2024 versus the reality of 2020 pre-COVID.
yes, and also the reality that our Constitution also doesn't push on certain things. These witnesses pre-trial couldn't be the most or more substantively important. We're not talking about outlier witnesses here. It is the heart of this.
And you're welcome to challenge this.
Again, it's not just me coming in here.
The government signs it.
I'm representing the history of all the people who weighed in the years, attorneys and judges who had an opportunity, and this was what was produced. It wasn't a quick matter. Certainly a change so quick this late is alarming. So I'll move on if there are no other
Yep,
points.
no.
But
Actually, sorry, can I ask
Yes.
one? Are there other circumstances in which a defendant may oppose a report or let me rephrase this. Are there other circumstances in which a witness can testify remotely despite a defendant's request that they testify in person?
no,
Okay.
no, that is the same issue, and that's what 26.2 governs.
Okay. Just
In
wanted to.
in a criminal case.
Yeah.
Right, because of the stakes are so high, because we're talking about incarceration.
Yeah.
Uh,
Just wanted to confirm that. Thank you.
yes. So moving on to the last piece, which was the suggested change to the, let's see,
Where are you?
it is,
She's looking.
yes, I think it's section 49 or 50, it's the AG's suggested amendment to the explicit images, disclosure of sexually explicit images in the chain.
Oh, the trail cams?
Yes, no, not the trail cam.
Oh, the Attorney General's language.
Yes, is that section, what section is that? I have it on 49 on this draft plan
Yeah, it's
too.
page 51,
51.
section 49.
So here, the change, the substantive change is to expanding the definition of digitization to account for the change technologies. From our perspective, whenever you tinker with this, you're treading on First Amendment grounds, right? Because most of the speech is protected, except for some special carve-out exceptions related to child pornography and things like that. And what we have here is something that still stays within the lines as I see it from this general definition. So we have no objection to the suggested language change here. So long as, and it stays here, that the person at issue is an identifiable person. So this is still consistent with the US Supreme Court. So on this issue. So no suggestions there.
But if maybe I'm misunderstanding the goal here, but I thought the goal was somebody that uses pornographic depiction of a person. Let's say it was Donald Trump sitting nude on the toilet. And obviously you don't have a picture of that, so somebody's AI did with his face. And so should that be against the law or shouldn't it? I guess that's the question.
And I understand that this proposal
And
is.
so, I saw that picture the other day on one of the comedy shows. I think it was Colbert, but could have been another one. So that's, I think, what we're talking about, right?
That's my understanding is what the
And
goal is.
is that you know, obviously, it was insulting to Mr. Trump, but, it was funny to the comedian, should that be a crime.
So again, just to confirm, the concerns really are on the page 9 competency language.
Okay.
But otherwise, no comment on the others. Thank you.
Thank you. Our next witness is Stuart Schurer, and I'm not sure we have the language, Stuart, that the administration is proposing, or do we? I missed it.
I think Ben passed that out earlier.
Ben, I'm sorry, I was out of the room with my doctor.
Is it included in that new guys?
Oh, that's the step change.
We're,
Here, let me, I don't know, I put it on the screen and I can also, I don't think it did.
I think it's just section 27.
section 27.
Of that big thing, and then I think there's some changes in the beginning, Stuart can walk you through what lines.
Yes, Senator, good morning.
Good morning, Stuart. Good to see you.
You too. For the record, Stuart Schurer, General Counsel for Department of Disabilities, Aging and Independent Living, commonly known as Dale.
Yeah, I thought we were finished ever talking about this again together.
I'm sorry, say that again?
I said, after last year's working group, I thought we were never going to have to talk about this again together because
I was hoping the same thing, but here we are.
Here we are.
I don't know if you have that language yet in front of you, but the way it was prepared for your review, it was as some language amending the version of the House bill. So if it needs to be pulled out of there and then added to H878, we
I think it can stay in here. They just have to, Senator Lyons will have to coordinate with us and taking a section out.
I don't, upon reflection, I'm not sure it's necessary to strike the language in section 27 of the bill. As I looked at it more carefully, it is permissive language. It says that the department may submit, what does it say? The department may submit an alternative proposal to the forensic facility to the House Committee on Human Services and Senate Committee on Health and Welfare. It doesn't require it. If the language that we were proposing today to this committee were included in the Judiciary bill, then I don't see much harm in leaving the language as it is in the House version as an option if we so choose to exercise it.
I think we're still trying to find the language.
I'm getting.
Okay.
That's the new language added to that.
All right. Sorry about this.
That's fine. I can try to resend it if you need me to.
No, I think we got it.
Okay.
No, we didn't get it.
What we have is evidently not what they sent.
Do we have it or don't we?
Nope, it's coming.
We need it, it's coming. Why don't you just describe the problem? And then
Sure.
we'll look at the language once we get it.
That
Because I've
sounds
only
like
got 25 minutes left.
okay. I don't have much to say on this, but thank you. So I was in the midst of being prepared to testify in House Judiciary, but I wanted to come down here and I will return up there when we're finished. But having reviewed the draft of S-192 as passed House Human Services and House Healthcare, we believe that while we support the bill as it currently exists, what's in the bill, that we believe that it fails to recognize that there is an urgent need for an alternative to the current option that the Dale Commissioner has for individuals who are extremely violent or who continually elope from programming under Act 248. Currently, the only option for the Commissioner for those placed in their custody is to put them into a community-based house or somewhere in the community living with a shared living provider or in a staffed home of that sort. Those homes are not by nature locked facilities. They're not secure. The individuals can in fact leave at any time, and they can wander off. They can commit new crimes. They can injure themselves or injure others. So we heard loudly and clearly from those two House committees their lack of interest in the forensic facility for individuals with intellectual disability. But at the same time, there was a call for additional community-based options to address those in Act 248 who are in fact too dangerous to be placed in an unsecure or non-secure community-based option. So that's precisely what this language does. It would provide the authority to Dale to develop secure community-based residential settings in which appropriate designated program can be provided and without placing the individual in a facility. We believe it's a reasonable alternative that allows individuals a place to receive the services and supports when that non-secure option is not suitable to protect the public. It's also an alternative to continued detention in a DOC facility when it's clear that a non-secure option will never be appropriate for that individual. Again, this option would be available pursuant to the Commissioner's authority to place the individual in the least restrictive setting, subject to the Commissioner's ongoing obligation to abide by the integration mandate in the ADA. So we believe that's.
I'm just going to make one comment, Stuart. It sounds like the House has completely thrown away the decisions of the Act 25 or 28 working group that I participated in and spent so much time on last fall. I am disappointed to the nth degree that a 14-3 or 14-4 vote out of that committee is completely ignored by the House of Representatives. And so I'm not willing to go along with that compromise. I think we made a decision and we should have a battle over it between the House and the Senate if need be. I don't like that compromise, so I'm willing to put in language, if the majority of the committee is, that would allow us to go forward with our decision in S-192. It is absolutely against everything that I believe in. You have people who are incarcerated who don't belong in prison because they won't allow them. I'm fine with developing community alternatives, but in the final analysis, it may be only a forensic facility. There's also the issue of the victims and victim notification in this issue that the House stripped out of. And I want that back in. So I'm not gonna play, this is the end of the session. I'd rather let the bill die than to play this game where the House of Representatives hold us hostage over an issue that was well decided. And members of the committee may disagree. I may not have 5 votes or 3 votes, but I'm gonna do everything I can to make sure that what the Act 48 working group decided, what the Senate Health and Welfare Committee decided, what the Senate decided is followed through.
Thank you, Senator. I certainly appreciate that. I know that there have been some intervening events that have made the House Healthcare Committee, for example, also make the decision that the forensic facility was not an appropriate option. A lot of it may have had to do with the fact that the 9 beds anticipated at the former Vermont Psychiatric Care Hospital, at the Vermont Psychiatric Care Hospital, would require a substantial amount of funding, although I don't know what that amount is at this point, to get it up and running as a forensic facility for those with mental illness and intellectual disabilities. As a result, the Department of Mental Health has decided that it can, with additional authority, utilize the River Valley Therapeutic Community Residence as, which is a 16-bed therapeutic community residence for individuals with mental illness who are in the custody of the commissioner as an alternative to those 9 beds at the psychiatric care hospital. So while we do believe that there is a need, we continue to believe, as did the majority of that working group you referred to, believe that a forensic facility is needed. We also recognize that in the short term, at least, the authority to develop community-based secured options, which of course will require some funding as well, be authorized so that we can at least take some action which could maybe be available more quickly than the funding of a forensic facility.
And what about the language regarding the victims? That get lost somewhere?
We're hearing from Jennifer Pullman's testifying right now in House Judiciary. I think that the language, she and I have spoken, and I think we're both pleased with the status of the language in the bill. There is a lot of parallel structure now between the authority of the victims to receive notice, and also I believe the House is proposed, the Judiciary Committee in the House is proposing some amended language to allow victims to submit victim impact statements at the time of discharge. So I think that's addressed. I don't know if there are any additional concerns from Jennifer and other folks.
We now have the language in front of us. It is section 27 of S-192. Do you want to walk us through that?
Certainly. Also, I don't know if that was provided to you, but there was some additional language added to the purpose section in section 1. Okay.
No, it hasn't been provided.
Okay.
It hasn't.
Yeah, the document that's provided is lengthy, so this is the operative part that can look at right now. It's take a little bit to print this up.
Okay, never mind. So why don't we go through section 27 and
Certainly.
see if the committee is willing to add this.
Okay. So as it was proposed, I believe to you, you'll see that that section 27 was struck. But as I said earlier, the language proposed by the House doesn't necessarily need to be struck. Since it is permissive language, it allows the department to submit an alternative proposal, but it doesn't mandate it. So instead, what we are suggesting is the addition of language that says that the department is authorized to construct, develop, purchase, or contract for one or more secure community-based residential settings at which the commissioner can provide appropriate care, custody, and rehabilitation in a designated program, including access to psychiatric, psychological, nursing, and medical care as needed. We believe this strikes a compromise, as you said, Senator, between what we, as a working group, felt was the best approach to what the House committees were suggesting their objections were, which was it shouldn't be a facility, but we should be looking at community-based options. So this is in fact a community-based option that would be more secure than what we ordinarily use for individuals. And it would have available to those folks who are in this program, in this community-based secure setting, access to all of the things that we would hope to provide in a forensic facility, which is psychiatric, psychological, nursing, and medical care, if those things are needed. There's a definition section that's added here that simply acknowledges what a designated program is. That's defined in Title 18. What secure means. That language is currently in S-192 in the mental health field pertaining to the use of the secure residential recovery facility. So it would mean it could be physically locked. And then the last provision, if in fact this had to be a licensed facility, which it would have to be a licensed, well, for lack of a better term, facility. If we were looking at a structure that accommodated 3 or more individuals, it would have to be licensed. If it has to be licensed, there's a potential that it could be required to go through the certificate of need process. So this language simply says that if we're talking about a location that would accommodate 3 or more individuals, it would be exempt from the certificate of need requirement. We do expect that if we had this authority, we would be looking at standalone homes, for example, that would accommodate 1 or 2 individuals and would not require licensing or a certificate of need likely. But this language leaves open the option that it could be for 1 or 2 individuals or licensed for 3 or more.
Good. I don't have a problem with this. I would suggest the section 28, the report provided to the House Healthcare Committee, as well as the House Healthcare Committee and the Senate Healthcare Committee.
That's on the competency restoration?
Yeah. Fiscal estimate, because you're talking about what it's gonna cost. And it's really a CON, that type of issue.
Mm-hmm.
You're not talking about programming, are you? I mean, I suppose you are, but I think it's more of a estimate of cost and CON issue.
That's what it appears to.
I'm gonna just suggest that we strike the Human Services Committee.
Question.
Sure.
How does the Department of Disability, how does Dale get this authorization?
Yeah. Of the House Healthcare.
And
How would Dale get the authorization without an appropriations attached to it in order to construct or retrofit a place? Or is that, yeah, how would this work?
Yeah, I think that's an excellent question. I think this is the first step. This is basically the authority to do this. It would likely require an appropriation, which is, we don't anticipate in this session. So I think that is something that we would have to pursue later on. But this is simply authorizing the commissioner to do this, and hopefully would set the groundwork for obtaining the necessary funding to construct this as a solution to this problem.
Thank you. Yeah, I'll support it.
Any other questions or comments on this section? Senator, I'm sorry, Eric Patrick.
Yeah, I just want to, thank you, Senator Sears. I want to make sure that we're talking about the same document here. Am I right that, I know we're just looking at, for the moment, section 27, 28, plus the statement of purpose that passed out. Is this, are we talking about the full 38-page document? That's what we're talking about adding?
No, just section 27 and 28.
Oh, that's it, 27, 28.
Yeah.
And any language in the purpose that needs to explain, I don't know if that's necessary in the miscellaneous bill, but that language was provided.
I don't think so.
Okay.
I think it's just, when I started this, somebody can speak up from DMH or whatever. When I started the conversation with the agency of Human Services that had the whole thing they wanted to put in, and I said that was too much for us to deal with since we hadn't dealt with Bill. But that the issue of what to do with the developmentally disabled group who commits serious crimes was something we had dealt with as part of prior bills, and I felt comfortable in putting those sections in. And so what they're giving to us is just these 2 sections.
All right, thank you.
And anybody with a comment on that, or committee members, or anybody else comment on that? But yes, at first they wanted to pull Bill. Does anybody have a problem with that? Okay. And does anybody have a problem with adding 150? That's the auto.
Oh, no,
Oh,
thank
no,
you.
not at all. That's the subrogation thing?
Yeah.
Yeah.
Oh, yeah, not at all.
Fine with that.
Okay, so Eric, if we can have a final draft tomorrow morning?
Yeah.
To vote on during your later time.
Well, the good thing is that slated time was for House bills, but you've been.
Well, we need to talk about it.
209,
We need to talk about S fifty-eight too.
Sounds good.
I wanna talk about the knowingly changes to S fifty-eight that the House did. So I'm not sure I understand what they did.
So that's the drug stuff?
Yeah.
That'd be Michelle, see what I mean?
Well, oh yes, it is.
That, I did the crazy age and the Big 12 portions of it.
Yeah, they didn't like some of them didn't like the Big 12, but I don't think they understood what we did.
And they passed.
Huh?
They passed.
Yeah, but who did the thing on housing? Because they took out the language that we had in there that I think explained it well, that tries to make sure that people don't go back to that Deckard house. And they, for some reason, they took out the language. Now, maybe they think it wasn't necessary, but I think at least it gave a message. So, I don't know who's in charge of those
John.
3 areas.
Yeah.
John is housing.
And Michelle.
And Michelle is
Know more
drugs.
about it, I guess.
Well, if John's not available, we have Michelle. So the 3 sections of S 58 are the knowingly section, the section on the house. Yeah. And did they make any other serious change?
No, Big 12, raise the age, they kept, as you guys had it.
They didn't change, raise the age?
Yeah.
Huh, Digger thought they did.
Senator, do you have anything else for me, or am
Oh,
I
no, I'm
free to
sorry,
go?
Stuart.
That's okay. I just didn't want to leave early. Take
No,
care.
Thank
Nice
you
seeing all
very
of you.
much. Have a great day.
Yeah, same to you.
I'll double check centers here, but I don't, they may have done a couple of technicals.
Well, Digger reported that they had made changes to that section, to the raise the age. That they did something.
Are we coming back to 876, the miscellaneous bill?
Maybe Digger got it wrong.
Huh?
Tomorrow, yeah.
Correction, the miscellaneous corrections
I
bill.
just wondered, section 3, what do we do with that? Is that going to joint legislative oversight? The earned times, that's
Yeah.
going to joint legislative oversight?
Yeah, okay.
Thanks.
Yeah. I mean, we're ready to adjourn.
Yes. I mean,